and he will be presenting the rest of
So,
our
hello everyone,
panel
and thank you for
participants.
attending our panel discussion with the title Will Russia's war against Ukraine bring some changes to the concept of the crime of genocide in the international law? And today we will have our main conversation, and after that we will have approximately up to 10 minutes for the questions from the audience. As I was presented, I'm a Valentin Serduk. I'm a legal analyst of the Center for Civil Liberties. I'm also a postgraduate student at the Department of International Law at Yaroslav Mudry National Law University. And today with me are very honorable speakers. They are Marko Milanovic, Professor of Public International Law, Faculty of Law, University of Reading. Zahar Tropin, PhD in Law, Associate Professor of the Department of International Law, Institute of International Relations at Taras Shevchenko National University of Kyiv. Katerina Busol, PhD in Law, Associate Professor at the Kyiv-Mohyla Academy and the British Institute of International and Comparative Law, Associate at the International Center for Transitional Justice. And Maxim Vishik, Senior Lecturer and PhD student at the Department of International and European Law, Faculty of Law, National University of Kyiv-Mohyla Academy. So without any further delays, I would like to begin our discussion. So on April 14th, 2022, the Verkhovna Rada of Ukraine adopted a statement of the commitment of the crime of genocide in Ukraine by Russia Federation. Such legal assessment of the actions of representatives of Russia Federation and the Russia Federation as a state itself has been repeatedly expressed by other Ukrainian authorities and Ukrainian international lawyers. However, at the same time, foreign lawyers have often expressed skepticism about this legal assessment. At the same time, the International Criminal Court takes a cautious stance, qualifying the mass deportations of Ukrainian children as a war crime, but not as a manifestation of genocide. It seems that these differences in views on legal assessments of the actions of the Russian Federation and its representatives are not least due to the fact that the concept of the crime of genocide under international law has remained unchanged for almost 80 years since the adoption of the Convention of the Prevention of Punishment of the Crime of Genocide in 1948. Don't the events of Russia's war against Ukraine indicate the need to change the concept of the crime of genocide? We will try to discuss this issue from several angles. And I would like to ask my first question to Professor Marko Milanovic. Professor, can you hear me clearly?
Yes, I can. Hi.
Excellent. So dear Professor, could you please share with us your opinion whether the current definition of genocide should be changed, or what may be probable proper ways of such changes? And I would also kindly ask you to provide some of your personal overview on the relationship between what happens right now in Ukraine and how it's connected to the situation globally. The floor is yours, please.
Thank you so much, Valentin. Thank you so much, and thank you for inviting me. It's a pleasure to be with you, if only virtually. I don't want to be provocative, especially because I'm the foreign lawyer, sort of as was noted in the introduction. But I think the answer to your question, will the international legal definition of genocide change due to the war in Ukraine, is, however you want to see it, is fortunately or unfortunately, the answer is clearly it won't. Like, the definition will not change. What can change, and that's not just due to Ukraine, it's also due to various other developments in the world today, including Gaza, is a more liberal approach to proving genocide, so to questions of proof. And I will turn to them at the sort of, in the final part of my analysis. Now, again, I am very aware of this kind of dynamic that I, who am not from Ukraine, is coming to you who are in Kyiv and you're under attack, and I'm telling you, the notion of genocide will not change. And I know how that can sound. But let me just give you a tiny bit of background so you understand where I'm coming from. And I am originally from the former Yugoslavia, from Serbia. That's where I'm actually coming to you from today on Zoom. And the same debate that you've had, we've had, in more poisonous terms, if I can put it that way. So now, in July 1995, we're commemorating, if I can put it that way, the 30th anniversary of the one event, one crime in Europe that was formally judicially established to be a genocide, and that's the July 1995 massacre of 7,000 or 8,000 Bosnian Muslim men and boys in Srebrenica in eastern Bosnia, which was done by Bosnian Serb troops. And I have spent decades of my life trying to persuade people in Serbia, for example, to believe in various crimes committed by Serbs, by Bosnian Serbs, including the Srebrenica genocide. And I can't really begin to describe to you how horrible that whole experience is, because whatever one does, one fails. And the level of denial and disbelief in crimes established through judgments of an international court, two international courts, is hard to explain. So today, 90% of ethnic Serbs deny in some way or another the Srebrenica genocide, right? But even worse than that are these horrible competitive victimhood type debates we've had here in the former Yugoslavia about whether something is or is not genocide. And perversely, everybody, every group, you know, in our ethnic conflict wants to be a victim of genocide and considers that to be a victim of some other crime, like a war crime or a crime against humanity, somehow lessens their victimhood, disrespects their experience. And therefore, we have had, again, decades of debates about whether Srebrenica is genocide or only a crime against humanity and that type of thing. And the dynamic we have had is one of consistently devaluating other international crimes, as if being a victim of a war crime is not sufficiently bad, as if crimes against humanity are peanuts, and as if genocide is the only crime that matters. And that is just a horrible type of debate, and one that we can witness today, not just in Ukraine, we can witness it in Gaza or Israel, Palestine more broadly, you name it. Pick a conflict, and you have these kinds of debates about genocide versus other crimes. Now, partly that's caused by a disconnect between how lawyers define genocide, or how genocide is defined in international law, and public, popular, political perceptions of that term, or how that term is even used in other disciplines. And the answer here, I mean, the point here I want to make is a very simple one. The way the Genocide Convention defines this term is stupid and amoral and not grounded in any principle. No one in their right mind today would write the definition of genocide the way it was written in Article 2 of the Genocide Convention. The reason it was written that way is because it was a political compromise that had to be concluded in 1948. Stalin was happy with that definition. He signed to it, you know, to the convention. You see what I mean? So it is narrow by only choosing some groups for protection, racial, religious, national, ethnic, and by focusing the whole idea, the whole notion of genocide on the specific intent of the perpetrator. If you went now around the streets of Kiev and asked people to define genocide for you, I am pretty sure no one would say, you know, genocide is different from other crimes because of specific intent. Yeah? Legally, that is how it is, though. Many opportunities have been had over these past 8 decades to change the definition. Every time that opportunity came, states and courts said, no, we're not going to change it. And partly that's also because the notion of crimes as humanity today encompasses all kinds of crimes in peacetime, and there is really no legal need to expand the definition of genocide. Now that leads to perverse situations. So for example, I was recently in Cambodia. More than 1 million people were killed by the Khmer Rouge on the killing fields. One group of Khmer killing another group of Khmer on the basis of their social class or status. That's not genocide. that's extermination as a crime against humanity. But killing tens of thousands of Vietnamese to destroy them as a group, or killing Cham Muslims in Cambodia, that is genocide. Yeah? So 1 million plus victims, that's not genocide. Tens of thousands of victims, that is genocide. Again, that's not a result that an ordinary person could understand or that is in any way morally justified, but that is what the law says. Yeah? Today, that whole debate now is being had not just with regard to Ukraine, as you know, but with regard to Gaza, where, I don't know, yesterday or the day before, the Der Spiegel published a whole big article about whether Gaza is genocide, with international lawyers discussing whether it's genocide or not. And there is just one sentence at the end, which is that even if it's not genocide, it could be crimes against humanity or war crimes. So it's a morally completely perverse debate, is my own view of the matter. So I don't see how that definition is going to be changed. It's not going to be changed either by Ukraine or with regard to Gaza or with regard to some other event. It is too difficult to find any kind of political consensus in the international community to rewrite the Genocide Convention, to rewrite the Rome Statute. Courts will not exceed their mandate by themselves engaging in interpretations that will essentially amend existing law. So there will be no change in the definition, even though I personally think the definition is a bad one. What can change, and this will be my final point, is approach to proof. So in criminal cases we've had so far, in Rwanda, here in Yugoslavia, and so on, the courts that are attempting to establish whether genocide is committed apply a very high standard of proof, beyond a reasonable doubt. If you want to quantify it, it's something like 90% certainty that something happened. And in particular, what needs to be proven by inference is that the persons who committed, say, the killings of thousands of people did so with this specific genocidal intent. And again, remember, here in Yugoslavia, it was only, quote unquote, Srebrenica where that proof was met. In Rwanda, it was much easier, right? Because you had 800,000 people killed by machete over a couple of months. It was, that kind of issue of proof did not arise, right? Now, however, we have cases being litigated before the ICJ that deal with Gambia, Myanmar. So this is the military of Burma or Myanmar has been doing to the Rohingya, and another case, South Africa versus Israel, that deals with Gaza. What the court might do in these kinds of cases is relax its own approach to evidence. Now, in the Bosnian genocide case and the Croatian genocide case, both brought against my country, Serbia, the court basically said, we will want fully convincing evidence that genocide was committed, and Srebrenica was the only such example during the entirety of the former Yugoslav wars. And in particular, the court will say, we will only draw inferences of intent if that's the only available reasonable explanation. Now, that high approach to proof is justified if you want to avoid a rather unhelpful situation where a criminal court says there's not sufficient proof of genocide, but a civil court like the ICJ says, well, maybe there was genocide. Now, in situations like Gaza or Gambia, Myanmar, you really don't have a criminal court in parallel, and it could very well be that the ICJ applies a more relaxed approach to proof. Whether that happens or does not, I have no way of knowing, but it could. The only message, again, that I want to reiterate, even though I understand that I'm preaching as a foreign lawyer to you guys in Ukraine, is that it is so corrosive of morality to devalue other international crimes and to continue insisting on genocide, that if I was you, I would try to explain to politicians, to the public, to society as a whole, how weird, how strange, how narrow the definition of genocide is in international law, and that people should frankly stop obsessing about it. So that is where I will finish. Thank you so much.
Thank you, dear professor, for your extensive observation. It was very deep. So now I would like to go straight forward to the Associate Professor Zahar. Zahar Tropin, please, could you tell us about general possibility of changes to the definition of the crime of genocide? And maybe you could also tell us about the Ukrainian experience in this matter and how it will influence on the future developments of the genocide concept because of Russian aggression against Ukraine. Thank you.
It's working, yeah. Thank you. Thank you for these questions, very interesting. And first of all, I would like to say to Professor Milanovic that to some kind of relief that at least professional circles in Ukraine do understand your points, and actually we from professional point and from understanding of international law, we agree with this, with your evaluation about the possibilities of changes of the concept of genocide in future. This is, at least from the professional point, it is, at least from my personal understanding, it is clear. Yes, as citizen of Ukraine, this is pity for me, but nevertheless, as professional, I do understand the reality of the international law and the realities which are within the international law. And actually, I do agree that the concept of genocide, the definition of genocide, will not change. And it's a pity, but events in Ukraine will not change the concept of genocide. And I think that there is two reasons of this. One was very greatly outlined by the Professor Milanovic, that actually the conservative approach, which is now within the international law and within the approach of states, of court institution, it will not be overcome. It is enforced. It is applicable by those institutions. And for example, the last decision of the ICJ on the Ukraine-Russia case on the Genocide Convention, it is great showing case of this. Again, ICJ took conservative approach and don't want to interpret conventions, not even this, but also other, in any extensive or progressive manner. They are taking conservative approach. And this approach is very widespread among the states, among the international law circles. That's why actually I think that concept will not change of the genocide. I also support this idea. But there is also a second point which it is necessary to outline. We are to be careful, and we are to bear in mind the possibilities of negative usage or misuse of any changes of the concept of genocide. Again, our case is very showing in this respect. Russian Federation, I will remind you, using concept of genocide as justification for the aggression against Ukraine. Again, they are saying that we are committing genocide. That's why they are justifying their aggression against us. So that's why, again, any changes to the concept of genocide, it is necessary to bear in mind that these changes may be used by such states as Russian Federation to justify the unlawful acts which they are committing or they want to commit against another state or something like that. So this is another point. And I also, my second point, again, it is some kind of echo with what was said by Professor Milanovic, that actually the concept will not change, but its application may change. And our experience, a very awful experience, but I think that it can introduce certain changes in the application of the concept of genocide. To my mind, actually, there is 2 points which can be, which can receive further international law development. At least on the approach, on the practical aspect, not changing documents, not changing, but at least in the in sense of application of law. First of all, it is issue of transfer of children from one group to another. The matter is that this type of genocide was not largely elaborated by scholars. It was not seriously investigated by international court institutions, and actually there was a lot of how to say information about this type of genocide. Why? Because yes, there were examples of such actions in history, but in such widespread extent and in such mass mass actions, which is now committed by Russian Federation, there is no such examples, at least in our recent history. That's why I think that this concept, this type of genocide and evidences about the commitment of genocide, a line of proving of this type of genocide, it may change. Especially taking into account that in Russian Federation, we have, I think, to my mind, actually, when we are talking about the transference of children from one group to another group, we have all classical elements of genocide. We have policy, we have systematic actions which are committed, and we have indoctrination, official indoctrination of those children. So actually, all those issues are within the actions of Russian Federation. So I think that this direction may be elaborated further. And it's a pity that there is still no, again, this is again very showing point that there is no ICC orders or decisions on this respect, and even some kind of preliminary. I know that the information is transmitted to ICC and they are conducting an investigation in this respect, but at least official reactions of ICC on this respect, I mean, in context of genocide, not as war crimes, but as genocide. There is no such reactions. Again, I think that this is influence of this conservative approach about the issues of genocide. But I hope that it will be possible to break this situation. This is first point. Another point, again, it will echo with those issues which were said by Professor Milanovic. It's about the changes of evidences and proving of genocide through the issues of contextual element and proving of intent. This is, again, very long and old discussion about whether the separate act may constitute the act of genocide. For example, when we have some act which is not grave, but it is, we have in this separate act specific and clear genocidal intent. Whether this separate act, can constitute the genocide. And again, here we have two absolutely different approaches by scholars mostly. That one say that yes, it is possible, this act can be qualified as genocide. Another scholar says no, we have to have systematic actions, gravity, we have to have plan, and so on and so forth. And this act is to be within the context of this plan. What is interesting, tribunals, there were certain decisions of tribunals which give possibility for this interpretation that separate act may constitute a genocide. For instance, tribunals in Yugoslavia and Rwanda, they stated that when there is a mass atrocity, where there is an atrocity, and if in the context of this atrocity there is a separate act of genocide, this separate act may be qualified as genocide. However, all those it was not so much elaboration of these tribunals on this respect, but even those elaborations, they were not supported by, again, states, other court institutions, and also by international law community. Due to this conservative approach. Again, I'm not, I just want to say that I'm not pro or contra. I'm just trying to explain my view on this point. And in this context, I think that Ukraine may use our possibilities of our criminal code, I mean Article 442, which actually doesn't refer to the contextual, I mean to the gravity or systematic nature. In accordance to the Article 442, if we will see its interpretation and so on, even separate act can be classified as genocide. And in this situation, we have a lot of examples when separate acts of Russian representatives of Russian forces, they are committed with specific intent against persons who are Ukrainians. And they are, in certain situations, specifically separate those persons. Existence of tattoos, respective, speaking in Ukrainian language, having Ukrainian passport without refusal to change it on Russian to Russian passport. So these are specific criteria in accordance to which Russian officials, forces, or any representatives, they are distinguish those whom they would like to torture, to kill, to punish, or to do something else. So in this situation, we have specific intent to make actions against on specific criteria. And having one case, having dozens of cases, having hundreds of cases, on our article 442, we will see the systematic nature of these crimes. And after this, I think it will be possible to prove some kind of, at least it will be possible to prove systematic nature. I don't think that it will be, okay, so I will be silent about other issues. And another point which is interesting, and I think that, and I, as lawyer, I don't have answer on this. It is influence on Russian propaganda. Because the influence of Russian mass media and propaganda and statements of Russian officials is of such kind that I think that for Russia, it's not necessary even to have a signed and approved plan. All other simply committing those actions because they think that they are natural and they are approved by silence by their superiors and commanders. And also another point interesting, this is a term which is used by Russian officials, denazification. I think that it is necessary to investigate the meaning of this term, how they and what they are putting in this term, again in the context of genocide. I would like to remind you that on the initial stages of the full-scale invasion, Russia officially used very broadly this term denazification. There was a period, then there was a period of silence when there was a lot of statements, but actually when there was a lot of statements by other states, by Ukraine, that, but when you are talking about the denazification, you are talking about the genocide of Ukrainians. And there was a silence. They stopped to use this term. Now they returned to this term. Next, on previous week, Lavrov again officially used the term denazification as demand for Ukraine. As for me, this term means it is there is no other interpretation as genocide. So what do you mean by denazification? To exterminate and to destroy all features of Ukrainian as nation, by all means. This is, from my perspective, it is genocide, and calling for genocide against Ukrainians. So I think that I will be stopped on that.
Thank you very much, Zakhar Volodymyrych, for your very interesting points, especially in regard to the deportation of children as a manifestation of the genocide, and especially about the Russians' propaganda in this matter. So moving next, I would like to ask my next question to the Maxim. Can you hear me?
Yeah, I can.
Oh, excellent. Dear Maxim, can you share with us your thoughts about why is it so important now to amend the crime of genocide construction? Maybe is there some possible ways to expand its interpretation? And according to the Ukrainian experience, maybe you could also highlight how the elements of crime of genocide should be interpreted when a national group is an intended object of destruction, and what a substantive basis for qualifying destruction of national group as a genocide. Please.
Yeah, thank you, and good morning, dear colleagues. It's my pleasure to be among you today. So I will just start by saying that I agree with Professor Milanovic on 2 points. So that the definition won't be amended, and that atrocities do not participate, as Professor Payamakhavan once said, in atrocity Olympics. I may stop here, but I'll expand. I'll expand on the first point. In the last 3 years, obviously, the discussion around the atrocities in Ukraine revitalized thinking again about the elements of the crime of genocide in the changing realities. And in these discussions, both among Ukrainian and foreign lawyers, I've noticed 2 radical tendencies on the spectrum. One tendency that I would call conservative, but when taken to the extremes, rather contextually blind, is using examples from the previous context as templates to say that there is no genocide in Ukraine because numbers are not there, modus operandi is not the same, the plan is not the same, methodology is not the same, victims are not the same, blah, blah, blah. And so I will quote one of my acquaintances who worked for the International Criminal Tribunal for the former Yugoslavia, once told me in my presence, "Oh, Ukraine is bad, but Ukraine is not Bosnia. Have you seen Srebrenica? Bosnia was bloody, and Ukraine is obviously bloody too, but have you ever seen Bosnia?" And the same goes to, have you ever seen Rwanda? Have you ever seen Holocaust? Obviously, Ukraine is bad, but Ukraine is not as bad as, and you name the previous context. So to me, this is not just about being conservative. This is about being contextually blind. To me, genocide, more than any other international crime, is contextually dependent. And contextually dependent to the extent that every element of the crime has its own shades, depending on what group is being targeted and how the group is being targeted. But then there is another radical side of the spectrum, which plays with, and I can say it as a Ukrainian, I know that foreign colleagues usually cannot, the card of Ukrainian exceptionalism, saying that we as Ukraine suffer from atrocities, that's why we can amend the definition of genocide either by ourselves, or we can force international community to do something to amend the definition of genocide. And within this side of the spectrum, we see multiple arguments, talking about expansion of the list of protected groups to include the groups that were clearly excluded from the conventional scope of protection, to expand the scope of underlying acts, in particular to include the notion of the so-called cultural genocide, or also to cover acts that by their very nature are incapable of demonstrating special intent. And by that, I especially mean attacks on energy infrastructure or other indiscriminate conduct. And I will refer here to the transfer of children too, because the line of argument I sometimes hear is that at least we have one underlying act proven, the transfer of children, so at least we have that. When people tend to forget that, yes, you do have the underlying act, but no, you don't necessarily have the evidence of special intent. So evidence of special intent is another mile to go after you have this underlying act in the form of transfer of children. So this approach is also equally doubtful because yes, Ukraine can amend how the crime has been interpreted, but when you start throwing everything into one basket that is called the crime of genocide, the crime loses its true meaning. Because then, as the parallel that I made yesterday is, this is to me the same as saying thank you every minute or every day. When you say thank you for every possible occasion, the word thank you loses its meaning. The same with the word genocide. If you try to include every possible atrocity or discriminatory or persecutory conduct within the definition of genocide, it loses its true meaning. So ending this preliminary overview, I find both sides of the spectrum quite wrong, and the truth lies somewhere in the middle. I find that Ukraine cannot, or we more broadly as community of international lawyers, we cannot amend the definition itself. Let's remember that the Genocide Convention was only adopted because there was this unique window of opportunities and a lot of political consensus put into the definition. But what we can do as international lawyers, including as Ukrainian international lawyers, we can influence how the crime is being interpreted. And to me, how Ukraine can definitely do it is by asking one question and then answering one question. How do you kill a nation? To me, this is a fundamental discussion that has been omitted in more broadly the law of genocide, because let's accept one truth: the law of genocide is highly fragmented. I usually joke to my students when we talk about the crime of genocide that if I was ever about to be accused in international crime, I would never want it to be the crime of genocide, just because I would never know what I will be accused of. The elements of the crime have been interpreted so differently by different national and national jurisdictions that sometimes it takes a lot of time to make sense out of those elements of crimes. But Ukraine can ask this important question, how do you kill a nation? And by asking that question, there are two sub-questions. What is a nation? What is a national group? And then what does it mean to destroy a national group? So I'll start by the first one. As we know, the Genocide Convention protects 4 groups, among which there is an ethnic group and a national group, racial group and religious group. And international jurisprudence and doctrine developed 2 approaches to defining protected groups. One of them, if I may call it, is aggregationist, and another one, if I may, is distinctionist. Aggregationist basically that tells us that 4 protected groups are not autonomous categories. They're just 4 corners of a bigger bowl, which is a protected group in general, and therefore it is not important or it is not useful for the discussion to attribute autonomous or independent meaning to every protected group. While this approach may be justified in certain contexts, for example, in the context of Bosnian Muslims, the ICTY defined them as altogether racial, religious, national, and ethnic group. In other contexts, it is important to delineate every group separately, because only by asking what every group means independently, we can answer the question in every particular context, what is being the object of the destruction. So another distinctionist approach says that the aggregationist approach doesn't take into account the developments in the modern anthropology, where every group is a standalone entity. And so the distinctionist approach suggests that we have to define every group autonomously. I won't be talking about religious groups defined by the common religious denomination or racial groups defined by the fake social construct of physical features, but I'll talk about ethnic and national groups because they are especially relevant in the Ukrainian context. International jurisprudence tends to define national group in connection to common citizenship and reciprocal rights and duties among the group members, and ethnic group as a collection of people united by the same culture, language, traditions, etc. So this connection between national group and citizenship has often been contested by legal commentators, suggesting that yes, citizenship is important as a precondition, but citizenship does not necessarily make you a member of the national group. Citizenship is just a legal bond between you and the state. And so to be a member of the national group, you have to think about the modern concept of a nation. You have to think about deeper ties, united people based on the shared past and future, shared vision of the national project, and shared ties between themselves. So to illustrate that, there are Ukrainian citizens who are Russian collaborators who definitely want to be a part of Russia. So despite being Ukrainian citizens, they don't share reciprocal rights and duties with other members of the national group. That's why national group is a weird and complicated beast. In contrast to ethnic groups, for example, it is impossible to pinpoint exactly what makes you a nation. As one song that I really like says, I don't know what love is, but I know what it isn't. So the same way with the nation. Sometimes members of the national group do tend to feel it on the, I don't want to say spiritual, but on an intangible level, what exactly makes them nation. Common history sometimes common language, sometimes common culture, sometimes the joint vision of where we move together based on our values. So this moves me to the 2 definitions of a nation that can influence how we define national groups. One of them is ethnocultural, which says that membership in a nation is inherited and chosen based on common land, ancestry, and culture. And another one is political or consensual, which means that we all together, despite our origin, are members of the national group because we choose to be, because we want to be members of the national group. As we know, in history and in reality, these definitions are just, again, 2 radical sides of the spectrum, and truth is always somewhere in the middle. Every nation is both ethnoculturally to some extent, but consensual and political to some extent too. So this is why national groups are more complicated structures than, for example, ethnic groups. In the Ukrainian context, you can be a member of the Ukrainian nation when you are ethnically Russian, or ethnically Polish, or ethnically Ukrainian, or ethnically Crimean Tatar, or ethnically Hutsu. So this is why a national group is an umbrella to unite different ethnicities by the shared national project. So answering the second question and moving to my final point, how you then destroy a nation? if a nation more than any other protected group is based on these intangible, non-physical characteristics, how do you destroy a nation? And so there are two sub-questions I want to ask. The first one is, what does it mean to destroy? I know that Katarina wanted to talk about it more, so I will reserve it and just provide a few remarks. Usually when you open a textbook or a book on the law of genocide, the first thing you see is that genocide requires physical or biological destruction. And so people often confuse this phrase and destruction within the meaning of underlying acts, which have to be physical and biological. All five underlying acts have physical and biological destruction, and destruction in the meaning of the intent. Yes, indeed, some commentators and some judgments suggest that in the notion of the intent, destruction has to be physical and biological as well. But there are two counterpoints to that. The first one stems from domestic jurisprudence as further confirmed by the European Court of Human Rights, saying that the notion of genocide, the notion of the intent, may also cover destruction of a group as a social unit, not necessarily just as a physical or biologically as an entity. This approach is also supported by the reality on the ground in the practice of international tribunals. Let's also look at Srebrenica. 7,000 men were killed. They constituted 1/5 of the group, while the rest of the group, children, women, and elderly, did survive, were deported to another area. So yes, Srebrenica as a community was gone, but the remaining part of the group survived. And yes, the trial chamber and the appeal chamber went extra mile to make an argument saying that especially in the patriarchal society, destruction of a man can influence the biological survival of the group. But the truth remained that children did survive. Some women who could remarry did survive, but what was gone is the Srebrenica community. And we see in the ICTY practice this consistent reference to community, 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 community as a part of the group. So there is a room for an argument that destruction in the meaning of the intent, unlike the underlying acts, can be also destruction in a social way. Destruction of a group of part is part as a social entity. And the last point is, it is important to consider who we destroy while targeting the group. And this is about what me and my colleagues often label as destructive potential. There are certain group members whose destruction is so significant that it is likely to affect the group as a whole or the part of the group significantly. So we call it a leadership factor. And sometimes destruction of people who, by their official position or by their special qualities within the group, do influence opinions of the group, its actions, and the group's very survival. And so we can talk here about different forms of leaders: administrative, political, business, religious. But the truth is that these people constitute the connective tissue of the group. And so their removal makes the group just an amorphous mass of individual. Yes, individual members do survive, but the group as an entity is gone. And so this is what we see, especially in the Ukrainian context. We see how Russia is targeting people who in their very respective communities and occupied territories are especially emblematic of the group or essential to its survival. That's it from my side. I just want to ask a rhetorical question. The crime of genocide obviously evolves, but not just because definitions evolve or our visions evolve, but also because the world evolves and because of the media scrutiny and special public attention, perpetrators can no longer afford, usually, to act as they historically did. They can no longer afford blatant destruction of group members, on their way to destroy the group as a whole or its part. So the question, a rhetorical question to ask is, how do you destroy a nation in the 21st century when the whole world is watching you? Thank you. This is from me.
Thank you, Maxim, very much for your valuable points. And I would just like to clarify one small thing to you. If we're talking about the group of people who refuses to accept the passport of other country, of the occupying state, yes, who tries to occupy them, whether we can recognize them as groups that shall be protected or not. Please, can you share with us?
Do you mean by virtue of just them refusing to take a passport?
Yeah.
Well, it depends on to me, depends on the reasons why they do refuse to get a passport. If their refusal to get a passport is just an expression of a political position, then we cannot. I can't see the room for them to fall under the scope of any of the 4 protected groups, with the one caveat that as we know in Ukraine, refusal to get Russian passport is often the manifestation of the allegiance or loyalty to the Ukrainian state, to the Ukrainian nation. So if we explore a deeper level of connection where an individual associates its nationality with its membership in the national group and with its connection to the nation state, then we can make an argument that this expression is an expression of belonging to a national group, and that's why it can be one of the reasons to identify an individual as a part of the protected group. So the brief answer is, if it's just a manifestation of political position, I don't want to be Russian, that's it, but I don't care about Ukraine, then no. But if it's linked to a deeper self-identification with the Ukrainian nation, then I think there is a big room for argument that, yes, potentially they are a part of the national group.
Thank you, Maxim. Moving forward, I would like to ask my next question to our the last expert, Katerina Busel, Associate Professor. Please, can you tell us about potential for evolving interpretation of the concept of the crime of the destruction and other genocidal acts and the role of the domestic courts in this regard? Please, the floor is yours.
Thank you very much for the question, for having me. And I think I'm in a beneficial and tricky position because all my brilliant colleagues have presented their points, and I really would like to reflect, but hopefully without repeating the key things already said, including about destruction. I would just say that I agree with colleagues that the actual amendment of the concept within the Genocide Convention or within the Rome Statute, as we know it, seems unlikely in the nearest future. And I agree fully that the room, the scope for widening our reading of genocide and context-competent reading, fully agree with Mr. Vyshchuk on that, is there both for domestic courts, for universal jurisdiction proceedings, and for international courts. And I will situate my remarks on specific points of such enhanced reading regarding Ukraine, but also regarding other contexts, such as the Yazidis, for instance, which we already have seen done by the German proceedings. Regarding the concept of destruction, I think it's very important to distinguish these two readings of the concept of destruction and biological destruction as one of the prohibited genocidal acts, as Maxim has mentioned, but also as the destruction as a part of the wider genocidal intent. And one of the major frictions here that we have observed as lawyers is that oftentimes the argument is posed about cultural genocide and that allegedly it doesn't qualify for the purposes of destruction under existent international law on genocide. And I have to disagree here. I think we have wrongly juxtaposed destruction of cultural heritage or the access to cultural practices, the access to educational practices with physical destruction. Similarly to the deportation of children, the impediment to enjoyment of one's cultural heritage with the education and history really, to quote Fionnuala Ní Sheileán, shallows out a person's personality. They survive as a biological entity, but it's shallowed out of its historical, cultural, ethnic and national connections. So the more nuanced reading of the connections between the access to cultural heritage, education, and the physical survival, complete survival, not just biological survival, would be beneficial in the proceedings regarding genocide, both in domestic and international courts. And we have seen how the failure to engage with that has actually catalyzed change within other institutions. For instance, in the case of Ukraine, as the colleagues have noted, the genocide discussion is quite intense and tense. We have seen other approaches. For instance, the UN Human Rights Monitoring Mission on Ukraine is increasingly speaking about gradual cultural erasure. We have also seen the UN Committee on the Rights of the Child speaking about the impact of indoctrination and impeded access to enjoyment within history and culture by Ukrainian children and wider citizens in occupied territories. So we actually see the response in parallel tracks where the other UN treaty bodies or monitoring missions are trying to fill in the void which the jurists and the scholars working on genocide perhaps are not yet ready to pronounce in Ukraine's case at this point. The second point also raised by Mr. Vishuk is the point about context and history. I think it's striking how oftentimes in our discussion about the allegations of genocide, the legacy of oppression is not examined enough. In this case, I find it very hope-giving that Dr. Patricia Sellers, the former special advisor of the ICC Office of the Prosecutor on Slavery Crimes, in her newest policy on slavery crimes, has specifically outlined how the legacy and context of prosecutorial and slavery-related practices should inform the way we document them and the way we build prosecutions. And I think that this emphasis on the legacy of oppression should be there for all atrocity crimes, crucially also for the crime of genocide. The third crucial point is the one on national groups. As Ukrainian lawyers, we have often proposed to see the targeted group for the purposes of the genocide proceedings, which we have domestically, and we also have within the remit of the Eurojust partners, as a national political group. And I have noticed that particular overcautiousness by international lawyers who are very empathetic, but who are so overcautious about seeing this political add-on in the qualification of the targeted national group. And again, I think it's so important to stress that the definition of nationality may not be conditioned upon citizenship. The not-a-bomb approach is really overlived. And even the sociological surveys conducted throughout the full-scale invasion in Ukraine, for instance, I think have very illustratively shown that not only ethnic Ukrainians, but ethnic Russians, ethnic Georgians, and Russian-speaking Ukrainians, for that particular polling, identify themselves with the Ukrainian nation, and crucially, were not ready to any political or territorial concessions to Russia in response to this cessation of shelling. And I think we should provide more of this data for the more nuanced reading of a national group, and that it's not based on non-changeable affiliations of heritage or birth or citizenship in a particular country, but specifically in the context of Ukraine and our opposition to Russia. The biggest room for innovation I see as of now regarding the concept of direct and public incitement to genocide with respect to Russia-Ukraine situation. In international law, and we have seen this from travaux préparatoires, both for the Genocide Convention, for the Rome Statute, we have seen this repeated in the judgments of the ICTR, that incitement to genocide is an inchoate crime, which may be established before physical genocide on the ground has been qualified or is qualified at all. But in practice, both with the Holocaust, with the Streicher and Dietrich cases, and then with Rwanda, with the famous media trial, we have had both the physical genocide established and incitement to genocide. And I think as part of the legal strategy and thinking around this crime, there should be a twofold approach. First, the more concerted translation of the statements from Russian political and media figures. I don't think they're as much in the English, they're as much translated into English, French, and Spanish and Arabic as the incitements from other contexts are. And I really don't feel that the depth of horror coming from Russia political and media channels is truly understood. But also parallel to that, it's important to emphasize that if Ukraine in the domestic proceedings or if universal jurisdiction proceedings looking into the context of Ukraine managed to establish on the basis of robust fact and law, the accountability for direct and public incitement to genocide before the establishment of physical genocide on the ground, it will solidify what we have had in the travaux préparatoires and to the mentioned treaties, that incitement and the prosecution of incitement can have a preventive function, and that it may be established and qualified in a court of law before the physical genocide on the ground. I think until the escalation in Gaza, and obviously these events, they really impact the way Russia's aggression and the suffering of Ukrainians are read and covered in international media, in political circles. But both before and even since the escalation of the Gaza events, I would emphasize the role of the domestic courts and universal jurisdiction proceedings. With the context of the Yazidi community horrendously assaulted by ISIS, we have seen that the first judgment on genocide came from a German court and was confirmed eventually by a German federal court. So I know that many Ukrainian human rights groups and the Ukrainian Office of the Prosecutor General are very transparent and proactive in submitting evidence to partner prosecutors' offices in Europe, in Argentina and other countries globally. And it will be very beneficial to have also their reading on Russia's atrocities, including possibly genocide and public incitement to genocide in Ukraine. I would like, as I've tried to outline the rooms for improvement, and indeed that before the escalation in Gaza, in the already mentioned case of the Gambia and Myanmar, there were actually these interventions from the global north-south countries, Denmark, Canada, France, Germany, the Netherlands, and the UK, actually essentially calling the court in 2023 to expand their reading of genocidal acts and genocidal intention. Again, it's curious whether their position is the same with a pending South Africa case against Israel. But the incentive to expand the lenses, to pay more attention to the victimization of children, not only through deportation, but through other crimes, the increased attention to sexual and reproductive violence has been there and has been posed to the court as an appeal to expand the reading of the crime. So hopefully that will be maintained and Ukraine could also make these interventions. I would like to sum up by saying that while I outlined the key areas where more action is needed or where the improvement is possible and would be beneficial, not just for Ukraine, but for other contexts globally, for me as a lawyer, but first and foremost as a citizen, as a Ukrainian, it's crucial to see the quality of the proceedings, the criminal proceedings, the possible truth-seeking proceedings. If we manage to base them on the best legal analysis and very robust evidence, regardless of the charges that we use, I think it will help us maintain the robust and legitimate narrative about the legacy of Russia's aggression and its escalation since 2014. Thank you very much.
Thank you very much, Katerina, for your detailed overview, and especially when you mentioned that we should have very high standard procedures of qualification and the proof standards. It's very important. Thank you all for your main key points. And I would also like to ask a general question to all of you. So, as it was mentioned already a few times by several of our speakers, there are some different constructions of crime of genocide in different criminal codes of different countries, and which create some kind of fragmentation of the interpretation. So in your view, will this lead to, should we avoid the consequences of such expanded interpretation, for example, or will it create some important precedent sometime in the future, and it would be quite important to create maybe future practice according to this? So anyone who wants to start?
I think that I haven't right of I think that the differences which are in the different jurisdictions about the term or concept of genocide, I think that it's not a matter of fragmentation, it's just a reality. We have different legal systems. Those legal systems may differently interpret those issues. It's up to these legal systems. And as I told about about our article 442, we just for us it is necessary just to use those possibilities. I don't think that it will lead to some negative consequences. Again, I don't think that it is possible to evaluate this positively or negatively. This is reality. That's it. And we simply are to use the benefits of this situation.
Thank you. Anyone want to join? Your thoughts?
Yeah, I can. I have 2 points to make. The one, yesterday when we discussed a survey about the amendments to Ukrainian legislation, I remember in relation to every crime, I made this reference to the Yorkish decision by the European Court of Human Rights and then further decisions in relation to Baltic states and their criminalization of genocide. And I don't want to be overly critical these days, but I see a lot of Ukrainian practitioners or scholars saying, look at Yorgic. Yorgic is essentially telling you that in the context of interpretation of doubtful concepts in international crimes, national jurisdictions have some kind of leeway, a discretion to interpret the elements of the crime. And many people stopped here without mentioning the second part of the Yorgic test, as long as it is consistent with the essence of the offense under international law. So in other words, domestic jurisdictions do have certain discretion to criminalize, to interpret different international criminal crimes concepts differently, but only as long as it is consistent with the essence of the offense on the international level, which then entails that if it is not consistent with the essence of the offense on the international level, a state is stepping over the legality principle. So this is an important reservation to me, like a critical one in relation to how a state defines every international crime. States do have certain limited discretion or leeway in how they go, but if states want to go beyond or criminalize more, including the concepts that were excluded from the convention, then a state has to come up with a different name for that crime. A state cannot call something a crime of genocide if it goes far beyond the definition of the international law. A state can invent a different name for that crime, but it is not a crime of genocide. So this is the first thing. As to whether national jurisdictions can influence the way how the concept is being interpreted, I feel like, again, to a certain limited extent, arguably it can, like a uniform domestic practice can be subsequent practice in the meaning of treaty interpretation, but everything that depends on, again, its consistency, reliability, and uniformity. So if it's just a matter of several states introducing certain little changes to the definition of genocide, I don't think it is capable of influencing the way how the treaty has been interpreted. But if it is quite a uniform process and consistent one, which I haven't seen to date, then potentially it may. So these are two things to bear in mind, the essence of the offense thing, and then, yes, to the extent to which subsequent practice can influence treaty interpretation will always depend on its representativeness, reliability, consistency, and uniformity. Thank you.
Thank you, Maxim. Okay, so I would like to move to my second question. It's not about the definition of the crime of genocide. It's more like about when we're talking about the court decisions and other procedures, it means that the crime already has been committed. And what is there something we can find in the international law to protect those victims at the stage of the commission? For example, in African Union, they have provision in their charter enshrined that they provide humanitarian intervention, while in the UN charter it's illegal. So does the international law consist the answer how to save the victim during the commission of this crime?
Maybe I can come in here.
Please, Professor.
So, I mean, there's been long-standing debates about this whole idea of humanitarian intervention in international law, by which it is frequently meant, you know, a use of force in order to stop an ongoing genocide or some other atrocity in situations where the UN Security Council does not approve it. Like, that's the core problem. If we have the UN Security Council approving the use of force to protect civilians, that is legal. The problem is, what if the Security Council is blocked, as is the case with Ukraine or Russia, or with regard to the United States vetoing any resolution against Israel, with regard to Gaza and so on? Should states be able to act unilaterally? The answer is no. I mean, as a legal matter, carving out an exception from the prohibition of the use of force in order to prevent atrocities elsewhere is hugely problematic, because it is a type of exception that can easily be abused to such an extent that it'll obliterate the prohibition of the use of force. Russia relied precisely on such a doctrine, at least initially, to justify its invasion of Ukraine in 2022. 2 days ago, Israel bombed Syria, bombed the defense ministry in Damascus in order to prevent, so it says, the Druze in Syria from being attacked by the Syrian government, and so on and so forth. We don't need this. If there is some kind of extreme situation where, hundreds of thousands of people will die unless a state unilaterally acts to stop it, maybe such a situation will exist, like Rwanda could have been stopped, It is better in such situations to simply break international law and to save those people than to pretend we can have an exception that will not swallow up the rule. And just to reiterate one of my earlier points, if we are going to have such a rule, it should not depend on whether something is genocide or not, because hundreds of thousands of people can be killed even if something is not a genocide, right? So whatever one's idea about military intervention to save lives, it should not depend on whether there's a genocide.
Thank you.
I would like to add a couple of words. Only one point. I just want to remind that in Ukraine, Russian Federation case on genocide convention, again, as it was said, that the reason for Russia uses as justification the alleged commitment of genocide by Ukraine. One of the lines of the Ukrainian position is that genocide convention doesn't provide such form of protection as usage of force. This is one of the points which is outlined by the Ukraine in ICJ.
Thank you. So I think now we have enough time to the questions from the audience. So please, if you have questions, raise your hand and we will pass the mic to you.
Thank you, brilliant speakers, for bringing up so many interesting points. But I have a question about the transfer of children that you already devoted so much time to it. And there is no a secret that there is a lot of concurrent crimes according to the international law that can be mixed with genocide, and their transfer of children is very debatable because you have to also prove their intent. And even their arrest warrant to Putin and Lyubova Belova is exactly to this assigned to their same type of conduct. And the question is that yesterday, as we already spoke in one of the panel, there was a change to the criminal code to Ukraine, to the article 438. So this is a question probably more to our local laws, and in this article there was an additional type of conduct that was criminalized, and this is their transfer or deportation of a child or unjustified delay in repatriation of a child. In your opinion, introduction these new types of the conduct to their war crimes, can it be a hurdle to proving the genocide in Ukraine or internationally, or you think it's irrelevant, or any other ideas? Thank you.
I think that maybe this question was mostly to me. Yeah, you're absolutely correct by saying that when we will take the international crimes in some kind of line, due to the contextual elements or additional elements, we have some kind of line. It is not easy, but the easiest crime to prove is war crime, more or less. Then it is harder to prove crimes against humanity, and it is very hard to prove genocide. So in this situation, I think that such changes are important for the to have those episodes of crimes as war crimes, which then can be requalified as genocide, if, and not even if, when there will be evidences of genocide, of genocidal intent. But again, as I stated, taking into account systematic actions of Russian Federation, I think that and existence of policy of hiding those children, of erasing their origin, their indoctrination of children, and so on and so forth. I think those evidences are enough to prove that there is a genocidal act in this regard. But again, ICC choose approach that it is war crime. Why? Because it is easier to have it. But it doesn't mean that ICC will not requalify this case, this situation, because I will remind you that there were initial orders on war crimes, but then ICC issued orders on crimes against humanity.
If anyone got questions,
Valentin, I'm
please.
sorry, may I jump in to add to this question?
Oh, yeah, of course, please.
Thank you very much. Sorry, I kept raising the hand, but probably didn't see it. I just wanted to briefly restate that it's not uncommon for the ICC or for other tribunals to then expand the charges. So a particular act of sexual violence could constitute both a war crime of rape, for instance, and be also a crime against humanity of rape. So it will not be uncommon to expand the charges, to elevate the charges. And if anything, I think it was a very wise approach. I mean, there could be a question whether it was wise to start with the charges concerning the deportation of children. But when this conduct was chosen, I think it's actually very wise that it was initiated with a threshold of war crimes, which could be then elevated or expanded. I would say elevated because it introduces a certain hierarchy, but expanded to include the dimensions of a crime against humanity or a genocidal act. And a comment on the amendments to the criminal code, while the fact that a certain improvement has been made is definitely a positive one, specifically with Article 438 and the inclusion of this one additional charge of the deportation of children, I find it a little bit problematic because it kind of falls in between. On the one hand, we have seen the change of the title of Article 438 to war crimes to reflect the naming of the rape statute, yet the list of the crimes was not fully changed, but for this one particular a crime related to children. I think questions could be raised to whether it was wise to do so, and many human rights groups, including the ones that I'm affiliated with, they are obviously also inviting to provide more specificity on other types of serious violations of rules and customs of warfare and war crimes in particular, or for instance, different forms of conflict-related sexual violence. Thank you.
Thank you, Katerina.
There are no hands visible on the screen, so I'll just add very briefly. I want to reiterate my caution that I raised previously with the transfer of children as a genocidal act, because again, the transfer of children was initially put in the definition of cultural genocide as envisioned by Lemkin, but then migrated to 5 underlying acts with one particular logic in mind by different delegations. Transfer of children is not an act of cultural destruction, but this is the way in which you impact the biological survival of the group in the future. So this is why it is not enough just to transfer children of the group and erase their identity. You have to demonstrate that through the transfer of children, you impacted biological survival of the group. That is why I often caution that this is a wrong logic. We as Ukraine don't have already one genocidal act established, and this is transfer of children. And whether we want or not, we can then expand to other underlying acts. No, we don't. We don't have the act of transfer of children established, because to have special intent established in the transfer of children, you have to go to the community level, you have to go to the regional level in occupied territory and see what happened to the rest of the group. only in combination with the rest of the group, you can establish special intent in the transfer of children. So as a standalone conduct, it's not enough just to transfer children from the group. You have to see what happened to leaders, what happened to other emblematic people in the occupied territories, what happened to the community, national group on the community level, and then how transfer of children added up to other underlying acts. So this is why, to me, the transfer of children is not the easiest one to prove. It's actually the most difficult one, because you can easily prove infliction of serious harm or killing of emblematic group members, such as leaders, which extinguish the group on a community level. But it is much more difficult to prove that through transfer of children, you impacted biological survival of the group. So this is just my brief remark that we have to be really, really cautious with the transfer of children. And to me, it's easier to demonstrate other underlying acts and genocidal intent there than in the transfer of children.
Thank you, Maxim. Is there any raised hands in the Zoom? Because I can see, okay. So if anyone have question.
Yes, hello, my name is Igor Belyan. I'm a Ukrainian historian, journalist, and Detector Media. So I am a co-author of a research about Russian propaganda on Ukrainian children. It was published at Detector Media in late 2023. So I do have a question about maybe information strategy, how we need to communicate this issue of abducting Ukrainian children to different countries. Thank you.
Very important question.
I think this is a hard question to lawyers, how to communicate those issues.
There are no media experts here.
Yes. I think that what was said by colleagues very important is again actually what was, if I'm not mistaken, by Katerina, the translation of those statements made by Russian Federation. This is an important point because actually there is a lack of real information. We have propaganda from Russian Federation in which they are putting their words, their actions in the light which is actually in their favor. But to show their real texts, real statements, full statements, not just parts of what is said, it is important. I agree, and I just want to emphasize on this point. I don't know even what to say.
Okay, since there are no more questions from the audience, I would like to ask my last question. I think it's already been slightly discussed during the session, but could you maybe share your short points? Why is it the concept of the cultural genocide proposed by Raphael Lemkin hadn't been included in the original construction? So please, can you share with us some shortly remarks on this matter?
Well, the answer to that question is actually fairly straightforward. I mean, there's a drafting history of the convention. There's actually it used to be a complete mess, but now you actually have a good book edited by Philippa Webb and somebody else who present the drafting history in a very comprehensive way. And it's fairly clear what the answer is. The answer is that a lot of these states were doing things that were very similar to cultural genocide, either in the more distant past or in the more recent past, or even if for colonial powers at the moment they were concluding the convention. And they wanted to create a very narrow crime that would essentially cover the Holocaust, and more or less that's it, right? So that's what it was. Lemkin was hugely disappointed by how the convention ultimately turned out. And so it is simply the price that was paid for political compromise to have the first crime that international law recognized states could commit in peacetime. And the price to pay for that in 1948 was a very narrow crime.
Yeah, I'll continue briefly. Yeah, I support Marco in this because when you read from page 1 until page, I don't remember, 2000 of this commentary, it's fascinating, but it's also disappointing in a way how much information is missing from there, that sometimes you cannot really understand the intention of certain delegations in how they voice issues. But this was an entire back and forth when delegations tried to say, some of them tried to say, look, to impact the group survival, you don't have to extinguish everything, to exterminate every single member of the group. You can exterminate the identity of the group, and then you will have the same results. Yes, individuals will survive, but who are they without their identity? Other states in opposition to that said, look at the gravity of physical and biological destruction. Cultural genocide is horrific, but this is up to human rights protection to deal with. This is not an international crime. This is just human rights matters. So eventually, the difference in votes wasn't that significant, but cultural genocide didn't make it to the convention. The same way as Raphael Lemkin initially outlined, if I'm not mistaken, 8 what he called techniques of genocide, not just cultural, but economic, social, and others. They equally didn't make it to the convention. So to Lemkin, every way in which you try to destroy the group was equal because the result was the same. But as Katerina said, I feel like it is equally contextually blind to say cultural genocide is not genocide, full stop. Cultural genocide, number one, is still important to demonstrate the intent and often accompanies acts of physical and biological destruction. But secondly, you see how certain acts of cultural genocide, what was called cultural genocide, migrated then into the interpretation of the ICTY and subsequent chambers. By that, I mean especially what I call the leadership factor. So initially, Lemkin said, expulsion or targeting of the group leaders who are emblematic of the group leaves the rest of the group just an amorphous mass. And this is an act of cultural destruction. The ICTY took that, brought that in and said, this is an important consideration to establish the intent to destroy physically or biologically because leaders are the connected tissue. The same way the New Zealand delegation said, what if you destroy all the old members of the group, physically or biologically? They are the barriers, the carriers of the group traditions and identity. So if you destroy the old members and then indoctrinate the younger one, you don't have a group. So to conclude with that, yes, cultural genocide is not in the convention, but if the remaining features are still here and there if you try to assess the genocidal intent. And I'll give the floor to Katerina.
Thank you very much, Maxima. Just a small add-on. I think we should not allow or try not to allow the previous mistakes and omissions from perpetuating the blindnesses. And, you know, cultural aspects are not included in the Genocide Convention or the genocide provision of the Rome Statute, nor are the sexual violence convention, sexual violence aspects, right? But we have seen them increasingly being developed upon in the interpretation of genocidal act and the genocidal intent. But at the same time, we have also seen the similar blindnesses. I've already mentioned today the case of the Yazidis, and on a domestic level, it wasn't just the first finding of genocide, but it was also the first finding of the genocide by against the Yazidis by the German courts by means of enslavement. However, there were also horrendous destruction of cultural heritage of the Yazidis, and Yazidis in numerous public appeals and during also the hearings in Germany did emphasize how the destruction of their legacy has impacted the preservation of their identity as a group. But that was not emphasized enough, was not emphasized that much. So again, we can also speak about the possibilities now to expand our lenses as human rights lawyers who submit evidence, as investigators, prosecutors, and judges. In a similar vein, in the Syrian universal jurisdiction cases in Germany, in the first Syrian case, it was only the crimes of torture and killings that were charged, and only then they were expanded to include also various sexual violence charges. So what I'm just trying to say is that the lack of the charges, expressed charges in the text, should not prevent us from including this nuanced reading, especially of the very intangible and under-prosecuted crimes into the proceedings we are building today. Thank you.
Sorry, if I may, I'll be annoying today. Just one last remark from me. That is why I call genocide probably the most contextual crimes, a crime out of all international crimes. That's because the construction of every protected group dictates how you establish the intent. Let's imagine you exterminate all religious leaders in a country where a religious minority has just 2,000 members. Killing of all the priests will amount to the crime of genocide just because you behead the religious group. The same way, if we go back to Srebrenica, what did the tribunal say? it paid attention to the highly patriarchal Bosnian Muslim society and how the destruction of the man impacted the survival of the group because of the importance of the man for education purposes, for cultural purposes. And then women couldn't remarry because of the cultural and religious traditions. That's why in any other protected group, maybe the extermination of that part of the population wouldn't amount to the genocidal act, but only because of the internal dynamics in the Bosnian Muslim society it did. So this is why cultural aspects, despite the absence of the convention, remain so important in how you define the internal group dynamics, and then how do you evaluate them externally from the perspective of the intent.
Sorry, can I now be annoying? So
yeah,
I got a bit triggered by your whole, super contextual assessment and the supposedly particular situation in Bosnia where in a sort of anti-feminist approach, if I can put it that way, the tribunal, the ICTY said the people in the Balkans are so backward, I'm not putting it in a harsh way, that women cannot survive without the men. But if the same thing happened in France, where women are emancipated, it would not be genocide. I mean, that's not how it really is here, if I can put it that way. The reason why the court needed to get into that kind of explanation is that Srebrenica has this weird dynamic where only, quote unquote, the men are killed and the women are not. So the reason why Srebrenica is labeled as genocide is because 7,000 people get killed in this industrial way. And they get buried into mass graves, and then they get reburied. You know what I mean? Like when you see it, your brain tells you genocide. The legal niceties and all the contextual la-la is really the court simply justifying the outcome that it think it needed to reach. You see what I mean? Sorry.
Yeah, I agree completely. Also, if you look at the appeal judgment, you can see that how they desperately try to put the biological lenses there. That's why I also mentioned the social destruction as well, because putting it in the individual perspective, what if I am a Bosnian Muslim woman and I do want to remarry, or I don't necessarily belong to that religious minority, or I'm Bosnian Muslim children, and technically I can reestablish my community. Technically, I can continue the group survival, it's just my community is gone. So yeah, I agree.
So thank you very much, dear speakers, for your thoughtful contributions. Unfortunately, we are approaching to the end of our discussion, and thank you all for participating, and we are waiting to look forward to your participation in our next events. So let's greet our speakers.